Hi, I'm Brent Stafford, and this is RegWatch by RegulatorWatch.com. Legislative overkill. That's how lawyers for the Canadian Vaping Association characterize new provisions that regulate vaping in Quebec's recently updated Tobacco Control Act. The National Association representing the vaping industry just filed in Quebec Superior Court its constitutional challenge to Bill 44, a challenge which will require the province of Quebec to demonstrate that its vaping restrictions are proportionate and balanced. The CVA lawsuit argues the new regulations cannot be justified in a free and democratic society. The legal challenge cites both the Canadian and Quebec Charters of Rights and Freedoms, claiming the new vaping restrictions infringe on the right to security of the person and freedom of expression. The suit challenges various aspects of the law, including the ban on demonstrating, sampling, and using vaping devices within specialized vape shops, arguing the ban impedes access to a product that helps smokers reduce health risks. Citing freedom of expression, the suit also challenges the restrictions on advertising that prevent the vaping industry from promoting its products, even to smokers. And the suit also challenges the regulation that in certain circumstances prevents vape shops from displaying vapor products in store. Joining us today is Audrey Bochter, partner at Irving Mitchell Kalachman in Montreal, one of the country's top litigation firms specializing in constitutional law. Audrey, thanks for joining us. You're one of the lawyers heading up the CVA's legal challenge in Quebec. Please update our viewers on the status of the lawsuit.
We filed today a constitutional challenge to certain provisions of the Tobacco Control Act. What that means is that the Canadian Vaping Association challenges the constitutionality of certain articles of the law. The challenge is based on freedom of expression as well as life, liberty, and security of the person.
So what does that mean for the first one, freedom of expression?
The Charter of Rights and Freedoms guarantees to all Canadians the right to express themselves. The government has a right to limit that expression, but only within limits that are acceptable in a democratic society. So our challenge is, we accept that the government can regulate, of course, but the government has to regulate within the confines of the Constitution. And in our view, there are certain provisions of the Tobacco Control Act that just simply go too far.
And what are those provisions?
For us, the most important is this ability to be able to offer a product with full information and in a manner that is the safest for the customer. So, our members want to be able to invite the customer into the store to be able to demonstrate how to use the product and to be able to actually allow the client to test the product in the store in order to ensure that the client understands how to use it, understands how the dosaging works. It's really in order for the client to most benefit from what the product offers in terms of an alternative to smoking. They need to be able to test it and learn how to use it.
So Audrey, under the new regulations, what you just described is restricted. Retailers cannot provide that education and demonstration of vaping products. So how does that infringe on constitutional rights?
It's a very fundamental issue of security of the person. By imposing these restrictions, people are actually prevented from accessing a product that offers them a possibility to reduce the harms of smoking in a manner that is safe, that is most safe for them and most conducive to have that product actually succeed in helping them.
And Audrey, we know a lot of smokers have turned to vaping to help them quit smoking, but yet the Quebec government is legislating vaping products as tobacco products. Are they going too far?
The state of scientific research is fairly strong in supporting that it is a safer alternative that can actually help smokers to reduce or even quit smoking. So instead of vaping kind of being treated as the patch or as Nicorette, it's being treated exactly the same as smoking. And in our view, that's just that's where the legislative overkill comes from, and it's really for the government to justify that choice.
So Audrey, if the government has to provide justification to back up the regulations, how difficult is it going to be to challenge the law?
I think a constitutional challenge is always difficult, but I believe that we have really very strong arguments. I mean, the jurisprudence is fairly clear that commercial speech is protected speech, so there's certainly an infringement of freedom of expression rights here. What it will come down to is it'll be for the government to justify that those restrictions are justified in a free and democratic society. So there were cases going many years back that had to do with advertising, constitutional challenges to advertising that were launched by the tobacco companies. And in those cases, some provisions were upheld and others were struck down, but the burden was on the government to demonstrate that there was a clear harm that was being targeted and that the measures were proportionate or were balanced with respect to the harm that the legislation was seeking to target. So the government's going to have to do the same demonstration here. And in our view, the harm from smoking is just not the same as it is in the vaping context. So I think it's going to be a much higher hurdle for the government to step over. So
you mentioned, Audrey, the tobacco companies. Imperial Tobacco is coming in with a challenge to the law, and there's also a lawsuit by the AQV, a group of independent vape shop owners in Quebec. It sure looks as if the Quebec government is coming under fire.
Well, they're now facing a number of challenges to this legislation. The restrictions to freedom of expression are fairly clear. All expression is prima facie protected unless it's incitement to hatred or something like that. So Canada protects freedom of expression very, very, very strongly. So we are quite confident that the violation of freedom of expression has been made out here, and it will be for the government to justify the choices that they've made. Now, of course, courts do give deference to the choices of the legislator, but they still need to make evidence and demonstrate that these are necessary restrictions in a free and democratic society like ours.
Audrey, even though the suit has been filed, is there still an opportunity to work with the Quebec government to change the law?
I mean, the Canadian Vaping Association has always been open to dialogue with governments, both at the federal and provincial level. So the Canadian Vaping Association would surely welcome the opportunity to discuss these matters with the government. Really, the ball is in their court.
How important is the CVA's role in this lawsuit?
I think that the CVA is going to be of great benefit to the court just because it has that pan-Canadian experience and it has members across the country, and the CVA has been involved with these issues in almost every province in Canada. So it brings to bear not just a dedication to these issues, but also a lot of experience and expertise that will be a great benefit.
Finally, Audrey, do you have a message for our viewers in Quebec?
Je dirais, soyez confiants, mais soyez patients. Et sachez que l'association fait tout dans son pouvoir afin de protéger vos droits.
Well, that's it for this edition of RegWatch. Before you head off, please like us on Facebook and don't forget to follow us on Twitter. For RegulatorWatch.com, I'm Brent Stafford.